Good evening, everyone. This is Christine, and for tonight, we are going to discuss the topic about the effects of guarantee, which will cover Articles 2058 until 2065. Before we proceed, let us first revisit what a guarantee means. It was comprehensively discussed by one of our classmates that a guarantee is a contract between a guarantor and a creditor. Thus, Article 2047 of the Civil Code defined guarantee as a contract whereby a person, called the guarantor, binds himself to the creditor to fulfill the obligation of the principal debtor in case the latter should fail to do so. And now, we are going to learn the effects of a guarantee. Now, if you are a guarantor, what are your effects? And if you're a creditor, what are also the effects? As per Article 2058, it reads that the guarantor cannot be compelled to pay the creditor unless the latter has exhausted all the property of the debtor and has resorted to all the legal remedies against the debtor. So, what does this article mean? Well, it talks about two things. First are the rights of the guarantor, and number two are the duties of the creditor. Should you be the guarantor in a contract, what would be your rights? Number one, you do not have the principal liability in case the debtor fails to pay the debt or could not even pay the debt. The reason behind is that the rule contained in this article arises from the character of the contract of guarantee, which is accessory and subsidiary. Thus, the guarantor is only secondarily liable. And should the debtor fulfill its obligation, the guarantor now is also freed or discharged from any liability, as he is only the secondary liability of this contract. Now, the second one is that the guarantor is protected by the benefit of exclusion or exhaustion, which means that the law requires the creditor to exhaust all the properties of the principal debtor first and to resort all legal remedies against the debtor. The mere declaration of being insolvent by the debtor does not warrant the guarantor's liability for payment or fulfillment of the guaranteed obligation. Now, to reiterate, the benefit of exhaustion should be in the guarantor's favor, and should there be a failure or non-payment or non-fulfillment of the obligation by the debtor, the creditor must not hold the guarantor primarily liable unless if he has already exhausted all the legal remedies against the principal debtor. How about if you are the creditor in this case? What would be your duties? Well, it is already a well-settled rule that only a guarantor may demand or may be protected by the benefits of exclusion or exhaustion. It should not be a mortgager or even a pledger. Now, in order for this creditor to compel the guarantor to pay for the non-fulfillment of the debtor's obligation, the debtor's properties must first be exhausted before the creditor can go after the guarantor's property to be levied upon. Thus, the creditor may only chase the guarantor after the judgment has been obtained. And further, the action brought to court should be filed against the debtor alone, for he is the primarily liable of the obligation. Next, the law only allows the creditor to a deferment of execution. It is the duty of the creditor to secure a judgment against the guarantor only after all the legal remedies against the principal debtor has been exhausted. We have learned on the previous article that the general rule is the creditor must exhaust all the properties of the principal debtor first, and that the creditor has resorted to all the legal remedies before compelling the guarantor to pay for the debtor's debt. Well, there are exceptions to this rule. Number one is that it should be provided by Article 2059 of the Civil Code, which states that first, if the guarantor has expressly renounced it, or simply means that if the guarantor has expressly waived its rights. Second, if he has found himself solidarily liable to the debtor. In this case, the guarantor simply assumes liability that of the surety, and it now becomes suretyship. Third, in case of insolvency of the debtor, which means that the guarantor himself has guaranteed and proven the insolvency of the debtor by the return of the unsatisfied writ of execution and has been determined by the final liquidation of its estate. Fourth, when he has absconded or cannot be sued within the Philippines unless he has left a manager or representative. Now, absconded here means that the debtor is nowhere to be found or is currently hiding. And another case is when the debtor cannot be sued by the Philippine courts, then this warrants the creditor to go after the guarantor, unless if the debtor has a representative or a manager or has left a message to its representative. Now let us proceed to the second exception. If he does not comply with Article 2060. We will discuss this exception thoroughly on the preceding article. Third, if he does not if he bounds himself solidarily with the debtor. Now this provision is similar with Article 2059 of Section 2, which he assumes the liability of that of the surety. Fourth is if he is a judicial bondsman and sub-surety. In Article 2084, it explains that the bondsman and sub-surety are not mere guarantors. Rather, they are sureties, to which are not entitled to demand for exhaustion. Fifth, where a pledge or mortgage has been given by him as a special surety or security. And sixth, if he fails to interpose it as a defense before judgment is rendered against him. In the previous article on the exceptions, it was stated in Section 2 that if a guarantor does not comply with Article 2060, he shall no longer have the right to demand for an exemption. Article 2060 provides that in order that the guarantor may make use of the benefit of exclusion, he must set it up against the creditor upon the latter's demand for payment from him, and point out to the creditor available property of the debtor within the Philippine territory sufficient to cover the amount of debt. In this article, we will understand how demand for payment from the guarantor should be made by the creditor. So, when should the demand be made? Article 2060 expresses that the demand for payment upon the guarantor can be made only after judgment against the debtor, following the principle on the benefits of exhaustion. In addition, there must be an actual demand made, because by mere joining of the guarantor in the suit does not entirely mean that a demand has already been made. This article also expresses that even though that the law grants the guarantor a right for the exhaustion, it should not be used as a pretext to delay or make it difficult for the guarantor to exercise its right to collect. Thus, as soon as the guarantor or the debtor is required to pay, the guarantor must also point out to the creditor the available properties of the debtor within the Philippine territory. The failure of the guarantor to point out to the creditor the debtor's property forecloses his right to set up the defense of exclusion or exhaustion. Article 2061 speaks of cases on the negligence of the creditor after the guarantor has already fulfilled the conditions for making use of the benefit of exhaustion or exhaustion. Now, if the guarantor has already pointed out the properties of the debtor, it shall now be the creditor's duty to exhaust all in order to satisfy its debt. Now, if he fails to do so, he shall suffer the loss, but only to the extent of the value of the said property for insolvency of the debtor. In connection to Article 2061, Article 2062 tackles about the duty of the creditor to notify the guarantor in the action against the debtor, such as its inability to pay or maybe the insolvency of the debtor. Well, under this article, notice to the guarantor is mandatory in the action against the principal debtor. The guarantor, however, is not duty-bound to appear in the case, and his non-appearance shall not constitute default with its consequential effect. The rationale is that for the notification is to only give the guarantor the opportunity to allege and substantiate whatever defenses he may have against the principal obligation and chances to set up defenses if he desires to do so. While Article 2063 explains the effects of a compromise agreement entered between the creditor and the principal debtor, and a compromise between the guarantor and the creditor. But before anything else, let us define a compromise. A compromise is a contract whereby the parties, by making reciprocal concessions, avoid a litigation or put an end to one already commenced. Now let us cite an example. A owes 1 million to B with C as the guarantor. A and B agreed to reduce the debt to 800,000. A did not pay its debt to B. So C here as the guarantor, after the exhaustion, is now liable to pay B, but shall benefit from the compromised value of 800,000 pesos. However, if A and B agreed to increase the debt to 1.2 million, and upon A's default, which C is now held liable of the debt after the exhaustion, C here will not be prejudiced from the compromise. Hence, he shall only be liable to pay the original debt of 1 million and not the 1.2 million which has been agreed by A and B. Now here's another case. It is when a compromise is between a guarantor and a creditor. The debtor benefits it, but does not prejudice him. We will again make use of the same example earlier, where A owes 1 million to B with C as the guarantor. Now, in this case, if the agreement is between B and C, whereby A is given an extension of time to pay, such extension accrues to the benefit of A as the principal debtor. But a compromise between B and C shortening the period for payment is not binding upon A because the same cannot prejudice him. As mentioned earlier, a guarantor has a right to demand for exhaustion or exclusion. How about if there is a sub-guarantor? Article 2064 provides the rights of the guarantor to exhaustion or exclusion. It also allows sub-guarantors to enjoy the rights or benefit of exclusion from the principal debtor as well as its guarantor. This is because he stands with respect to the guarantor on the same footing. While Article 2065 discusses the relationship of several guarantors or co-guarantors of the same debt and how they affect each other. Now, these co-guarantors of the same debt to one creditor are entitled to the benefit of division. Therefore, the benefit of division only applies when there are several guarantors and only one debtor for a single debt. With regard to its liability, all are jointly liable, however, only to the extent of each of their shares. Now, in case that the obligation to answer for the debt is divided among all of them, the guarantors are not liable to the creditor beyond the shares which they are respectively bound to pay, except when there is an express stipulation of solidarity. And let us answer a bar Q&A from the 2017 bar examinations. And here is a question. Kevin signed a loan agreement with ABC Bank. To secure payment, Kevin requested his girlfriend Roselle to execute a document entitled Continuing Guarantee Agreement, whereby she expressly agreed to be solidarily liable for the obligation of Kevin. Question. Can ABC Bank proceed directly against Roselle upon Kevin's default, even without proceeding against Kevin first? Explain your answer. And this is the suggested answer. Yes, despite the designation of the contract as a continuing guarantee agreement, the terms of the document must prevail. Roselle here expressly agreed to be solidarily liable for the obligation of Kevin. And according to paragraph 2 of Article 2059 of the new Civil Code, this is an exception to the rule. It states that if a person binds himself solidarily liable with the principal debtor, the contract now is converted or called as a suretyship. Thus, Roselle now assumes the liability of that of a surety.